Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to none.
Welcome back, everyone, and thank you, AJ, for the raid. Apparently, we are about to end this hearing if Todd Mullis will get a new trial. I am on team highly not likely with the evidence we have seen so far. I just don't think there's enough new evidence. They must have written some reports that raise some kind of doubt about something, but either it's because they are that bad at eliciting these informations, or it's because, I don't know, but I just don't think there's enough new stuff coming in that the judge will rule in favor of a new trial. I have to say. I know a lot of people out there saying he deserves a new trial, and he most likely does, what I have read and what I've heard from Jamie. But I just don't think we have been presented with enough evidence to overrule not just a case, but also an appeal process, sadly. I don't know how long the judge have to wait to make a ruling. It has nothing to do with how much time. She already read all the papers. She already made up her mind. And in a case like this, you are coming from, this isn't about the normal, presumed innocent and all of this. He is convicted. He is sentenced. He has an appeal overturned. So they have to prove something quite groundbreaking to get a new trial going. And I just can't see it. The only thing that I think is new and which was good was the biomechanical engineer, because she kind of did the stuff that the ME didn't do. She looked on the wound path, and I just don't think it'll be enough. I you know me, I'll even when it could be good for me to be the cheerleader and go around and say, oh, but of course he will, and tell all your friends to come watch with me because I'll sell you whatever you like. No, I'm the red pill machine. I just don't think they have done enough, and I think by the way the judge have ruled on the objections and stuff like that, I just don't see it. I'm sorry. Yeah. Um, I think if he had had a better lawyer at the first trial, you could possibly have raised some reasonable doubt. But at this point, you have such a big mountain to overcome. Hey, brokenhearted. Adia thinks they got it right the first time. Well, thank you. That's nice. That's now Jamie's not here, so finally someone can agree with me. Oh, Charlie is coming to Tennessee. Well, it's going to be fun. Bring bail money. Could be interesting to know who, if any, are coming to Tennessee. I just know that Mo is coming and now Farley. So it could be cool. Hey, Rolling Stone. Been a second. Of course, the local streamers will be there as well, but Brandy sounded kind of like she was interested yesterday. I have to tell the expert to reach out to her and have a talk with her. Well, I know how Farrell... I've seen the pictures from Las Vegas. I know... let's just say Courtney Clenny ain't got nothing on Farrell. And, of course, also the OnlyFans content. I've also seen that, so... Yeah, and the good thing is people return when life calms down a bit. I was just on the Twitch sweat, and someone was saying, because someone uploaded a clip from Brother Counsel yesterday, and they were, oh, where did that come from? From this stream. And we have so many streams and so little time, and yeah, that's a big problem. And us streamers, we don't plan with each other when we are going to stream because we're all independent creators. And I thought Sunday, 2 p.m., no one is streaming on Sundays. Sundays are always boring. I get beard meets food, and yeah, that's the only... No, and Windows SEO 40 Warhammer 40k streams is all the content I get new on Sundays. So I thought, I'm going to do it. Then Mike had one planned, Melanie Little had it planned, and Turtle Boy had one planned. So yeah, there was a lot of stuff going on all of a sudden for a Sunday. Oh. Yes, the meetup in Tennessee like last year. I'll be in Knoxville. Jinder wants to go to Tennessee, but Jinder have to save money to try and get to Norway next year. Well, don't go to Norway. Norway is... Well, then I am canceling my tickets. If Valhalla's going to be there, we have enough beef that I don't need to be in the same state as him. I don't need to be in the same country as him. I thought he would be re-enlisting with the Navy now that you have to protect Greenland. But...
Please be seated.
Oh, I thought Kaiser couldn't make it this week.
Okay, we'll go back on the record. Just before lunch, both parties rested in terms of calling live witnesses. However, I think at least the applicant has additional witnesses to identify by deposition. Is that correct, counsel?
Yes, Your Honor, I believe they're on the exhibit list, and the court would like we can go through them.
Yes, let's do that, please.
Exhibit 204, Turbot 2019 deposition.
Okay.
And I believe that both of these have already been submitted.
Yeah, we did some of them maybe at the beginning.
Yes.
Yeah.
Are we just going to sit here and walk the two papers?
There's 258, Hemisath 2019 deposition.
All right, you show both 204 and 258 as having been previously admitted.
Okay. And then, Your Honor, 301 is TRM video deposition from 2019.
And that was previously admitted.
Okay. And then 316, 2024 deposition of Peggy Munson.
Was previously admitted.
317, deposition of Jonathan Turbot, 2023.
.317 was previously admitted.
Your Honor, is it okay if I just read a few of the next numbers to verify?
Certainly.
318 through 326 should all be depositions taken in 2023 of witnesses. I think the 323 would be one the state would want to talk about.
Yes, I agree with that, Your Honor.
That we want to talk about it?
Yeah, that we would want to talk about 323.
Yes. And I do not show 325 as being admitted.
And that would be the addition.
Thank you, Phoenix, for being a member for 8 months. Is this just going to be a stream where they are talking about depositions? Because the judge have read these depositions, or allegedly have read or will read these depositions later. So they're not going to talk about them. They're just going to put them into evidence, and then hopefully at some point we'll get those 15 minutes closing from both sides.
Additional one that the parties have agreed upon.
All right, thank you.
And then, Your Honor, just to verify.
By the way, Farley, have you seen who is now entering the grifter sphere as a new commentator on law stuff? Casey Anthony. She's going to be an advocate for her daughter.
327 through 337 are also depositions. And I don't believe earlier we admitted 337, as that was Mr. Thomas.
I'm sorry, counsel, can you tell me those numbers one more time?
327 through 337.
Sorry.
My notes show that it was admitted, but either way, we have no objection to that.
Okay, and that's what my notes show as well, that those would have been part of a stipulated group from, Tuesday of last week, so.
And then the last of the depositions should be 338 through 344, and I believe we've already all agreed and admitted those.
Yes, I show that those have all been admitted.
And 346 And 352 got left off that page.
I show both 346 and 352 as admitted.
And then 355.
This is a little boring, so let's do something else instead when we can catch up and speed run this. For those of you who don't know.
Saturday, March 1st, 2025. This is my first of probably many recordings on a series that I'm starting. I am a legal advocate. I am a researcher. I've been in the legal field since 2011. And in this capacity, I feel that it's necessary, if I'm going to continue to operate appropriately as a legal advocate, that I start to advocate for myself and also advocate for my daughter. For those of you who don't know, my name is Casey Anthony. My daughter is Kaylee Anthony. My parents are George and Cindy Anthony. This is not about them. This is not in response to anything that they have said or done. That's not to say that I'm not going to respond at some point to some of the things that they have said and done. The whole point of this is for me to begin to reintroduce myself. I'm doing this.
Come on, relax now. She is an advocate for her daughter, and it's not about her parents at all. She's now going to introduce herself so we can hear why we want to follow her. I normally always take my legal advice or my advocacies from people who do the crooked car streams. Dave used to do it a lot when he was calling in and he was having lunch. But I find it's more trustworthy, it's more real if you're sitting in a car doing that. I will forego streaming from my studio from now on. I'll just sit out in Ophelia, that's what I call my car. And I'll probably freeze my butt off, and it'll be really hard to do the streaming. But if you just turn on your live the YouTube on another channel, we can kind of do it because I think it lends authenticity to the streaming. And I can't tell, but that shitty tattoo on her arm, is it a brand name or is it a memory of her daughter? It looks really, really cheap.
Both personally for me, but in a professional capacity. Moving forward, the majority of what you will see will be me speaking in a professional capacity.
She'll be speaking in a professional capacity, which would, in my opinion, then mean she will be hired to talk for someone. She'll be a spokesperson for someone, because I don't speak in a professional capacity. I'm a YouTube grifter. I have a business that runs my channel, but I'm not a professional. I don't know what her professional capacity will be and in what field it is. Bottle service, losing your daughter. Again, who hasn't lost a kid or two? Come on now.
My goal is to continue to help give a voice to people, to give people tools and resources that they can utilize so they actually know where they can turn to. So with that, please join me on Substack. If you have questions, I will set up an email address where we can correspond directly. Up until this point, that has never happened. And it's only going to be on a limited basis regarding legal issues, legal matters. One of the main reasons
I really, really, really hope she doesn't do that. Because I've never been on Substack, but I'm pretty sure it's against their TOS to give legal advice.
reasons that I'm doing this, there are people close to me who have been targeted and attacked recently. There are also people close to me who have had some recent things occur. And when necessary, people needed to step up, myself included. So as a proponent for the LGBTQ community, for our legal community, women's rights. I feel that it's important that I use this platform that was thrust upon me and now look at as a blessing as opposed to the curse that it has been since 2008. With that, these aren't going to be perfect. They're not going to be edited. Most of the time, they're not going to be short. But I am proverbially standing in the light, embracing this piece, still going to keep my privacy intact. So you will get very comfortable with my car. And
Yes, car streams.
I will explain in great detail why it's so important for people.
Cars is actually a great place to stream from because they have all this soft padding. So it's sounding softer than my room. That's also why I have the boards to try and absorb some of all the sound bouncing. But cars is the way to go. And she is verbally, what did she say, standing in the light of something.
People to protect their privacy. It's not just important to public figures, it's even more important to private individuals. And with the current climate in our country especially, it's that much more important, which is why I am utilizing the Substack platform. Yes, I am advertising this and publishing this on TikTok, possibly also through other meta platforms, but my intention is to separate from that and showcase even more why Substack is such an important resource for people to utilize moving forward. Anyway, I appreciate your time and we'll see how this goes.
We will see how this goes. And for those of you who asked, what if any is Substack, which is a very important tool to use in this political climate. It is kind of like Patreon or Locals, I think is the one that's connected to Rumble. It's pay to play. You can sign up to follow your, kind of like you're subbing to me, but you'll have to pay. I think like the normal thing on most of those are like $5 or $10 a month. I did search for Casey Anthony. I can't find anything related to her. Maybe she didn't set it up yet. But why does this sound more like she's getting paid by Substack to use their platform? I don't know. But Farrell, she will be having an email address. I know for one, you will be contacting that and asking, how hot is hell and do you enjoy staying there? I do my Rumble videos every day in my closet. I'm a closet Rumbler. Yeah, it's good for the acoustics. And if Substack doesn't work out, there's always OF. Allegedly, according to quite knowledgeable Pew Pew YouTuber, the attack on Amaranth was 100% real. So I was wrong. The dogs didn't know them. And she was just luring them to a studio where she could pew pew them while texting doing. This is called BS. You can use big words and people will still hate you. Well, I use $1 words and people hate me. As someone wrote after my stream yesterday, misinformation site. I don't know what and why we got called misinformation, but people are idiots. As someone said, someone shared a post on Facebook about, I can't say beyond reasonable doubt that Karen Reed killed John O'Keefe, but there's so much evidence pointing to it. Then she's innocent, you idiot, because it's beyond a reasonable doubt.
355 is admitted.
I'm just gonna have this running in the
Record you wish to make on that point, Mr. Baki?
Oh.
Correct his testimony.
All right.
Mr. Thomas.
Objection to that.
Okay, and that's what my notes show as well, that those would have been part of a stipulated group from, Tuesday of last week, so.
And then the last of the deposition should be 338 through 344.
Yeah, I love that she's now an advocate for LGBTQPI. She's against the current government. She's pro-women. And I can't even remember the last. It was just word salad. Those are four of the most basic things that you can run on that can get you views. There's a reason why I don't touch politics and religion, even though it would be so easy to sit and yell either Republican buzzwords or Democrat buzzwords, because you'll get an inbuilt following and you'll get an inbuilt hate group, but hate views is still views. And politics, it's the same. And advocating for minorities and sexual groups, it makes you unassailable, because you'll just say, well, you only hate me because I stand up for this minority group. No, we hate you because someone isn't here anymore. Well, join my Substack. And I'm just sad that I couldn't find her on Substack because I wanted to see her prices. It's $2 to be a member at my channel. If you are that, you get no real special benefits. I release videos earlier. I don't even charge for Discord because I'm not a good enough grifter.
I believe we've already all agreed and admitted those.
Yes, I showed it.
I have the same mindset as Michael Jordan. When he was asked why he never spoke about politics, he said, Republican buy sneakers too. And you can turn it around and say, Democrats buy sneakers too. If I want to alienate 50% of you, I could just stream topless instead.
Those have all been admitted.
346, and 352 got left off that page.
I hate you.
I show both 346 and 352 as admitted.
And then 355.
355 is admitted.
So the only one we would be asking to admit that the state's objecting to it this time is the deposition of Jake Firehelm from 2023.
No. Someone testified that he didn't think it was murder because it didn't look like someone had staged a murder scene. And then his sister said, yeah, he thinks he's innocent. Now we're just putting in previously taken depositions, because then the judge will read them.
Marked as 323. Applicant recognizes Mr. Firehelm did testify, but his deposition had to be utilized multiple times during his testimony to refresh him or to correct his testimony. And we think it's appropriate at this time to ask the court to admit it for the proper weight of what it was used for.
Counsel?
And the state would object to the admission of the deposition. And I would just note for clarity of the record that this was a discovery deposition. I believe it was taken before the state even had the benefit of receiving discovery. Not that there was any problem with that, given the timing of when it occurred, that was to be expected. However, given the timing, the fact that it was a discovery deposition, it, in the state's opinion, does not make sense to admit it. And as Mr. Firehelm testified in his testimony here on Friday, confirmed that he did not have his own file when he had that deposition. I believe the parties were able to adequately impeach or refresh his recollection based on his deposition, so his testimony should remain as what he gave in court.
Any further argument in support of your request to admit 323, Ms. Nichols-Cook?
Your Honor, I think our goal here is a complete record for the court to have, and it is additional sworn testimony that Mr. Firehelm gave in addition to the affidavit that he signed and was shown. And I believe the deposition will assist the court in evaluating his credibility and his testimony this week.
323 will be admitted.
Thank you, Your Honor. Your Honor, I believe the parties have an agreement as to Exhibit 371. This is a DCI Google search comparison chart.
Has Casey Anthony, before the case, she was a bottle girl. I'm not one to look down on women who sells alcohol. Great job if you can do it. But I don't think it's kind of like the wonderful women who works at the mouth here. It's not the most financial responsible people who normally have jobs like that. Isn't there a high Colombian inspired recreational thing going on with people like that? It's not like they're gonna make millions, or like one of the smart people in the anti-can read group said. It's not. They're making 3 figures.
Created by Roman Gamble, and we would seek to admit it.
I show 371 as having been previously admitted.
I believe it was referred to during Sheriff Hemeseth's testimony. However, in any event, we have no objection to it. I believe he laid sufficient foundation for that.
Okay, if it wasn't previously admitted, it will be at this point.
And Your Honor, I know in our last witness, we talked about 375, the jail call records. We would still move to admit for the court's consideration.
Down payment on moop picks. Well, you can sign up for my highly uncensored OF. Only $2,500 a month. So 12 and a half more down payments and you can get 1 month. That's enough. I only have 2 picks. One is a feed pick and the other one is a moop pick. But still, worth it. $2,500 a month.
Just the September 22nd, 2019 phone call recording that is within that exhibit. It might be more as an offer of proof because of the objections that were made to its admission, and ask that it be admitted as an offer of proof.
375 was the number? Okay.
There's many phone call recordings within that electronic exhibit, and we're just specifically asking for the September 22nd, 2019 call. I apologize, I don't have a better way of identifying it for you.
Okay, I guess to the extent it's being, or the court's being asked to consider it as an offer of proof, any additional record you wish to make on that point, Mr. Bakke?
Yes, Your Honor. The state objects to the admission of the jail call for the reasons already stated and addressed in the record, hearsay, among others.
Moop pick is $2,500 a month.
I guess I'm confused what the purpose of admitting it for an offer of proof would be.
Well, we had a poll earlier, and that was I think 50% said no, 60% said no new trial. I can do another poll. We have nothing to do. Look at JVH. Someone is really someone is good today. And PlanFam has all the dissuasion. Hey, don't hate the grifter, hate the game.
At this point, when no additional witness testimony is expected, so we would object.
9 a.m. Eastern, so you're in Wales. That'll be 2 o'clock your time.
To its admission.
Well, the court will consider it as an offer of proof, just so that it is part of the record for purposes of any further proceedings in this matter.
Thank you, Your Honor.
You can refile that.
Just that one.
All right. And I know we have some other exhibits to talk about. Ms. Nichols-Cook, is that?
I have never. Why should I have a new trial? I've never been convicted of anything. I don't know what rumors Jamie has been spreading about me, but I have never been convicted. It was consensual. And as long as the donkey was the giver, not the taker, it is okay.
Address all of the additional.
Oh, but I don't think there's enough there to give him a new trial.
Witness testimony that was coming in on behalf of the applicant through deposition.
Yes, Your Honor, there's one topic regarding Mr. Saber's deposition. The exhibits used in that deposition are separate exhibits on this court's trial exhibit list, and I know the state had some objections to some of those, and I don't know if the court would like me to identify which ones I believe are referenced in Saber's deposition for the record, or what's the best way to do that?
That's probably the best way to do it if they're not all contained within the same exhibit. So Mr. Saber's deposition is which number?
320, what? 323? 325.
Okay. And then the exhibits that go with Mr. Saber's deposition,
That would start at 219, Your Honor.
okay?
220. 223? Yes, 223, I'm sorry. 234. 235. 236. 237.
As I said today on
238.
Tommy's show,
239.
my liver couldn't handle living in Massachusetts.
240. Actually, through 246. And then 240. And 2.
I don't know if those are the ones that you're referring to, or if it is some of the newly identified exhibits that are troublesome, I guess. Mr. Bakke or Mr. Duden, did one of the two of you wish to identify which exhibits are objected to, or do you need a minute to confer?
To what we had previously expressed during our pretrial motions as well, that we would ask that those exhibits and depositions be considered for their weight because they do contain hearsay, rather than more so for the truth of the matter asserted. But we would also note that 252 has been previously admitted as a part of 233. I believe it's the later pages of 233 are in the middle section. Either way, for clarity of the record, we don't have an issue because it's cumulative and the court's already admitted it. And subject to the state's objection on the use of hearsay testimony in those exhibits, we don't have any objection to those being included here.
All right.
No, audio is fine. I'm just skipping because nothing's happening. They're just reading depositions into the record.
So 325, the deposition of Bob Savers was previously admitted. And then as I understand it, 219, 220, 223, 234, 235, 236, 237, 238, 239, 240 through 246, 247 through 252, and 278 will also be admitted, subject to any prior orders of the court limiting those exhibits.
Can't trust a man with a comb over.
And it's possible that at least one of those was already previously admitted.
Yes.
Okay, all right. Okay.
Okay, thank you, Your Honor. I think after that, it takes us into exhibits related to expert testimony. I believe those would be Exhibit 274, Dr. Bowley's report.
Broken Baker, not all heroes wear crepes. That's a reused one. Come on, Zach. Do better. No cricket for you today. But thank you.
279, Dr. Weck's report. 285, Dr. Nye's report. 276, the portion that is Dr. Hammer's report. 281, Mr. Safaric's report. That we would move to admit those. I understand the state has raised a concern that they could be improperly used to bolster or vouch the experts who did testify. However, expert witnesses are allowed to rely on other information and data under Rule 703. This is
But in Denmark, it's not a baker who makes the crepes. It's a chef.
something they testify they normally do in the course of offering an expert opinion. The data in 703 is not hearsay. It's also, this is a bench trial again. The court can afford the proper weight to these exhibits. And it goes to more than just, what Dr. Hammers and Dr. Nye testified to. It shows the prejudice of counsel's errors at the trial and provides that context for the court in the record of what is being discussed and reviewed. So even the reports don't have to be admitted for the truth of what they're saying, but it's for their use under 703.
Response.
the reports and information. As the court knows, we have always objected to the inclusion, especially of the reports and information present in this case from non-testifying experts. Those reports are being offered, in our opinion, either for a vouching purpose or for the truth of the matter asserted, and therefore are hearsay that would be impermissible for inclusion of the record here. But
I still should get my True Crime box wine shirt made. But my sales rep hasn't gotten back to me.
for the use of those reports, subject to the state's objection, we have no issue with the court taking it under advisement if they would like to evaluate it, given that prior discussions have occurred for instance, of Dr. Nye's first report as a mere report of vouching to the credibility determinations of Dr. Bowley or Bully, who did not testify here. In subject to our hearsay objection, I don't think there's any way around considering them for their truth value. So we would ask that they remain to be excluded in subject to the court's determination, but no further arguments necessary on these because we've maintained our objections from the very beginning before we came to trial.
The expert reports will be admitted subject to those objections, and my final order will clarify, I guess, to what extent, if at all, the court considers the opinions of the experts. Well, and let me clarify. I'm going to defer my determination of admission of the expert reports, and my final order will indicate to you what is admitted, because I do need to review those in more detail to determine if I can separate out any portion of the report that should not be admitted. And primarily that deals with the information from Bowley. Under the case law and under the rule, it really is the Bowley report that is problematic. I don't think that there is any way of interpreting the inclusion of Bowley's report in Dr. Nye's report, for example, as anything other than a conduit for getting Bowley's opinion in when it otherwise wouldn't come in. And that is not permissible under our rules and under our case law. And so I think it can be excised in all likelihood without damaging or taking away that portion of the work that Dr. Nye did, certainly from her second report. But I will clarify for the parties in a written ruling that in fact that is what I have done. And so with regard to the experts, that will be the plan that we follow with those reports.
Can I get clarity on just which exhibit numbers? I was a little slow in writing them down. I apologize.
Sure. So Bowley.
But the problem is, if neither side have swayed you, then he's not getting a new trial. He's in prison for life, and this is his last hope. If she's not granting him this trial, tough luck. You're going to be in prison for life.
I believe is her separate report is identified as 274. Let me just double check my numbers here. Yeah, 274. WECT is 279. Nye is 285. Hammers is 276. And Safaric is 281.
Yes. I think, and she's even shown a little leeway towards the defense because I think she knows the importance for them. So I think she's actually been quite pro-defense and given them some overrules where they probably shouldn't have had them.
And then, Your Honor, my friends in appeals would be remiss if I didn't ask to do this, but regarding the jail call that was submitted for the offer of proof, if I can read the name of that file into the record just so everyone is clear going forward what we were talking about, if there's no objection.
Go ahead.
My records show it is called 687-308-34_9-29-2019_08-12-58. And there's more to it, but I believe that should be sufficient to identify.
Thank you for that. I'm sure that'll be helpful for the court too in locating the particular call to the extent they would need to. So. Okay. Ms. Nichols-Cook, anything else that you wish to address with regard to exhibits?
Your Honor, I know that we all agree the underlying record is a part of this proceeding. I think we've realized we did not file the motion for new trial sentencing transcript from September 4th, 2020, and we would like that to be a part, of course, of the record. And if there's no objection, we can upload that today, and it would be like 978, I think.
Any objection to that, counsel?
No, Your Honor, it's already part of the record. If it's easier to have it filed here, no objection.
It doesn't make any difference to me. I mean, if you wish to have it marked as a separate exhibit in this file, that's fine. But certainly by statute, the underlying case file would be considered part of this record. So it's up to you, counsel, if you wish to have it marked separately.
I think so, Your Honor.
Okay.
Just for clarity, what's 977?
An email that the fire home was shown? Right? Okay. Your Honor, the next thing on my list is to address the photographs that were submitted as exhibits. Obviously, we did not show or utilize every photograph that had been proposed. And I think that we can identify a handful of them that we know were shown to witnesses that we believe should be a part of the record, but we also don't oppose the admission of additional photographs or the group exhibit in its entirety, if that's what the court would like.
Well, 500. So I show, for example, 500 through 580 as having been admitted, which I believe are all photos. And I know that we didn't, or the witness didn't talk specifically about all of those, but I do show that they've been admitted. Also 600 through 655, which I believe are all photos. And again, I know they weren't all specifically referenced, but I do show that they were admitted.
I believe 700 through 734 are DCI photographs. We would have no objection to those. I believe only 731 has been admitted thus far, but for what it's worth, we would not object to the 700 series.
Okay. Did you wish to offer those then at this time?
I would offer those then.
Be admitted. Those are the big groups that catch my eye.
Your Honor, I had 3 in the 900 series that related to Dr. Nye's testimony, and I'm happy to just identify those 3 for the record if that works.
I show 929 and 938 as being admitted.
Okay.
976, I think we were arguing about.
And I think for clarity, the photos are 800 through 975, so the third one that I have down is 890.
And I show 890 as being admitted.
For the courts to assist the court in understanding the testimony and as additional offers of proof, if not directly admissible, on their own.
Any response, counsel?
Yes, Your Honor. The state has, conveyed fundamental issues with the 14-page supplemental information that was included with Dr. Nye's testimony. Certainly, I think the parts that are worked with or were worked with during her testimony fall on pages 12 and 14. 12 being her calculation page that was referred to, and 14 being the citation page or references page. The state has no issue with the admission of pages 12 and 14. The rest is a little bit wonky, given that it is aspects or portions of other admitted exhibits, not Dr. Nye's work, but kind of like a drop document that was used for things that she'd want to refer to later. So we would object based upon hearsay in the inclusion specifically, as it wasn't in her expert reports, but would simply ask that the court accept the 14-page document subject to the state's objection and reserve ruling on it like the other expert report information specifically, given that it also includes portions of other experts' reports, like Dr. Hammer's, Dr. Boley, and other outlier information or demonstratives.
Right, 976 then will be treated in the same fashion as the, I guess, the substantive expert reports will be.
We are awaiting a signed stipulation declaration regarding exhibits 390 through 396.
Apparently, this has taken longer than the first trial. The first trial wasn't that long, according to Jamie.
There'll be two declarations from court administration to authenticate and lay the foundation for those exhibits. We would ask to be allowed to move those in upon receipt of those declarations.
Any objection to that on behalf of the state?
We don't know what the full declarations look like, so we would ask that the court allow us to defer. We don't anticipate there being any issue with the declarations, but some of the information was still kind of outstanding or highlighted within the judicial branch's declaration page.
Okay, I guess on that issue, then we technically probably just need to leave the record open to receive those.
Your Honor, we just received the signed one, so maybe if we circle back to this in 5 minutes.
Certainly,
sure
that works just fine. We'll do that.
Your Honor, I just had a couple left on my list to make a formal record on, that the applicant does seek to admit the affidavit of Carrie Piercebacher as identified as Exhibit 215, the affidavit of Jake Firehelm in 224, the affidavit of Donald Pottebaum in 379, as well as a transcript of the November 10th, 2018 911 call identified as Exhibit 294.
Response on behalf of the state.
To the extent, I do apologize that I was looking at the portions for the declarations. If my understanding is we're asked about the affidavit specifically.
Yes, of Carrie Piercebacher, Gerald Firehelm,
Mr. Pottebaum.
and then the transcript from the 911 call.
Yes, Your Honor, we would renew our objections to the admission of affidavits. I believe on Monday the court made clear on the record with regard to Carrie Piercebacher that affidavits wouldn't be admitted for the testimonial purposes that they've been sought for, especially for Mr. Pottebaum, for instance. We believe that testimony would be uncrossed and relatively inadmissible or misleading for the court, so it would be objected to on those grounds. We believe each one constitutes hearsay, and we already addressed, I believe, Ms. Piercebacher's affidavit, but we did allow without objection the admission of her report. So her affidavit was unnecessary, but we would renew our objections to the remainder of the affidavits. As for the transcript of the 911 call, our position is, as we said previously, we object to it on a hearsay ground, specifically that the record speaks for itself. The 911 call was subject to the Court of Appeals opinion. It was subject to being played in the underlying case for the trial, and certainly the court has engaged in some portions of prior rulings in the summary judgment phase or summary disposition phase here as it relates to those 911 calls and potential enhancements. Should the court wish to receive the certified transcript not for its truth value, but to assist or clarify the testimony of, say, Mr. Firehelm, for instance, we have no issue with the court receiving that subject to our objection and that it wouldn't be considered for its truth of the matter asserted.
The three affidavits that are being offered will not be admitted. Exhibit 294, I believe, is the 911 transcript, will be admitted.
I believe that is all I have, Your Honor. And then we do have a list going of demonstrative exhibits that we identified during testimony. And we would like perhaps a little time to provide that to counsel and then present them.
Yes, I guess there was a question between the parties, the best way to file those. In past cases, I've seen where the court files them as court exhibits. But beyond that, we don't have any problem with making a complete record. Our friends on the appellate side will appreciate the clarity.
Yeah, I do think they need to be made a part of the record, but it is important to distinguish them from the actual exhibits. And so I'm fine calling them court exhibits or demonstratives, just so that we're careful to keep them separate. They were all, I guess, paper, which helps, but if you would like to gather those up, and you can provide them to me if you'd like before we leave here today, and I can make sure that they get into the record. That's fine.
Thank you, Your Honor.
For purposes of closings, given that the demonstratives have been referred to fairly repeatedly as the same letters that cross over with the state's exhibits, referring to them as demonstrative, D or whatever, would be probably the easiest way of going forward. Is that okay with the court as well?
It is, yes.
Thank you. And we'll refer to ours for purposes of the record too with the court's permission. I think making a good record here is probably the easiest part. We refer to our exhibits as exhibits A, B, C, D, F, G, H, and I believe. But we did not admit exhibit E, and we have filed them as PCR-A, etc., simply because the underlying record, the other ones were unavailable. So we would ask that the court recognize or accept that while we may speak to our exhibits or the exhibits that have been admitted here as A, B, C, etc., that those exhibits be understood to mean PCR-A or B, etc.
This is the Innocent Project Group, I believe, who's running this. There's no other venue. He's already had his appeal. This is a civil case to try and open up the case. Unless some magical evidence pops up, I can't see he's ever getting another chance.
And I did note that in the electronic record and understood the correlation and the reason why they were labeled that way.
Sure. Thank you, Your Honor.
Anything else as far as exhibits or clarifications for the record on behalf of the applicant? Sure.
That the state will file here in a moment regarding Amy Bernal, and I think Your Honor, can I verify that Exhibit 314 medical records, which I don't believe was an objection to, was admitted?
I do not show 314 as having been admitted.
I'd likely to not show it as admitted. I don't believe we have an objection to them, especially considering that we stipulated on Dr. Thompson's deposition and files. However, given that it is medical information and has unredacted information as to be expected, we would ask for that to be at a heightened security level. I believe a level 1 would be adequate.
Okay. 314 will be admitted.
I don't believe I have anything else, Your Honor.
It this way, and I believe there was some question about security levels on a few of the exhibits. I believe most of the problematic ones weren't offered, so it should be minimal, but I don't know if maybe additional time before they're formally admitted, if the parties can, or if Mr. Mullis' counsel already knows if there's any additional ones that might need a heightened security level.
So other than 314,
I think because it's such a long shot, they might have brought in the B team for this one. They have been horrendous. The only slightly competent one is the angry, bespeckled lady. Laughy lady was okay when she stuck to the script, but she couldn't think on her feet. And the person or the one who's normally pulling up the exhibits, she couldn't even read her own questions Friday. The blonde one, I can't even remember how she asked, but it's been horrible. It's been really, really bad. Jamie and I, because Jamie really, really thinks he's getting a raw deal, and hey, Jamie, you have to look at the facts. He's not getting a new case with this defense, and he should have. Yeah, could have, would have, should have. I should be a millionaire, but it's not going to happen. I really don't see why they used this case to give them some trial experience, other than they probably knew it was a very long shot.
team that we just talked about, I can tell you that the only other one that I have a note on right now as needing a higher security level is 400.
Your Honor, I think the applicant would have no objection to any of the medical examiner photos being filed at a high security level, or Dr. Thompson's photo collection.
We have no objection with that. The 500 and 600 series photos. I do note, for whatever reason, it appears that they might not have been filed at a heightened security level in the underlying case. It's my opinion that had to have been an oversight. I don't know if that's something we can also resolve while the parties are all here, but
I think that if everyone is in agreement, I can probably address that.
Your Honor, the applicant would have no objection to increasing the security level of the photos in the criminal case. I think additionally there's a couple of photos in the 200s that were used in depositions that have been admitted that would also require a higher security level, and perhaps the autopsy report. So like 225 through 229.
as well as State's Exhibit B, which is an autopsy report as well.
Okay, I've got notes on those. The security level will be addressed in the court's exhibit management order. I believe that directs the parties to file any additions or corrections within 10 days or something to that effect. So certainly if the parties identify any additional changes that should be made with regard to not only the exhibits that are identified as having been admitted, but also the security levels that are established, certainly feel free to bring that to the court's attention so that changes can be made. I know that it's easier for clerk staff and certainly less work if it can be done up front rather than later on. So,
and I do, just as I was scrolling through this list, I do recognize there's probably going to be additional, such as 216, the EMT report has a date of birth. So maybe, so we do this once, if the court would be willing to defer filing of the exhibit order so the parties have time to go through the exhibits just to identify any confidential material for the time to.
that's certainly fine, counsel. If you'd like to confer and send me an email within the next day or two, we can wait to file that. That's not a problem at all. Thank you.
And Your Honor, I can confirm that the stipulation filing reached between the parties has been electronically signed, but also filed for the court's review and agreement here regarding Ms. Amy Burnow's testimony.
All right, thank you. And then, I guess maybe so I don't forget, I'll come back to the declaration and exhibits from court administration. I think that was 390 through 396. Has everybody had a chance to look at that, or do we need a little more time on that one?
I believe the 390 through 396 portions for the jury management questionnaires or jury-related information has already been redacted and provided, and the state has no dispute about the admission or foundation of that testimony or those exhibits being admitted here.
Okay. So the 390 through 396 will be admitted if I don't think they were previously.
Exhibit 397, it's a U.S. Census Bureau report. We would ask the court to take judicial notice of that exhibit.
Any objection to that, counsel?
Your Honor, I don't think we have any issue with the information in that exhibit being accepted as census information or anything like that. To the extent that the court wants to take judicial notice of that information, then we have no dispute or really any issue with it being admitted as census information.
Well, yeah, and I guess I understand the request to be that I would take judicial notice of it rather than admit it as an exhibit. So I'll notice it. So
Thank you, Your Honor.
yep.
Get to the closing and argument.
I'll jump over to state maybe for now. Any witness stipulations, exhibit issues on behalf of the state? I have not necessarily cross-referenced my list of notes as far as outstanding exhibit issues. Maybe for fear we'll discover more, but I think we've hit certainly the major things as far as exhibit reports.
I guess the only clarification, just to make sure that your list matches ours, that it's all except Exhibit E has been admitted. Then I believe we have covered everything as far as my notes reflected.
Have the parties compared notes as far as which exhibits of the applicants they think have been admitted?
No.
But we can do so when we verify our final list and information. We can either do it now, Your Honor, or we can do it at the time we do the protected information, but probably for purposes of closing, it might be easier just to do our closings and then verify that information after the fact, given the numerical changes and things like that.
I mean, it seems to me like it would be prudent just to be 100% certain that everybody's on the same page as far as what exhibits have been admitted before we leave here. I understand it's tedious and not super exciting to sit here and do that on the record, so we definitely don't need to do that, but maybe before you leave here today, and also just to make sure that my list appears to match as well, would be a good idea, because obviously there are a lot of exhibits in this case. But with that said, if you think that we have addressed all of the kind of lingering cleanup issues that we needed to, if you would like maybe a short break before closings, we could do that and then come back and wrap up.
Yes, Your Honor, the last thing I had to put on the record was that the court's order regarding summary judgment, any motion to reconsider or enlarge would be due this Friday, and the applicant would just request an extension to consider that.
The state's position?
If I recall correctly, the summary order regarding the court's positions on summary judgment said a longer order was forthcoming. Should the court be open to it, as well as applicants' counsel, I believe that the state would just request the opportunity for that deadline to toll until after the court's full ruling speaks to it, so that the actual questions and issues can be responded to specifically in addressing the court's specific decisions.
Yeah. I kind of like that idea. That maybe seems to me to be the most efficient use of everybody's time. Counsel for the applicant, does that
No
work for you
objection
guys?
to that plan, Your Honor.
Okay. So we'll plan on that approach, and just to have less dates to keep track of, maybe, if nothing else. So, okay. All right.
And then one last matter, I believe the court indicated brief deadlines would be addressed. Do you want to do that now or at the end?
We can talk about that now. Do either of you have a request as far as how long you would like to submit final legal authority to the court? I think I mentioned earlier, I'm not contemplating anything extensive. And really, unless you're telling me you are wanting something more substantial, I'm contemplating a one-shot 5-page limit focusing on legal authority that you believe is on point and controlling, and any particular testimony or evidence from the depositions that wasn't on the record these last few days, because I do have extensive notes from the testimony that we've been listening to. So if there's something that you want to draw my attention to from those depositions, obviously I will read them, but if there's something that you want to highlight, you could do that within that 5-page limit. Yeah, go ahead.
It's my understanding from what the court indicated previously that the court would consider the legal briefing on these issues that we already laid out in our summary.
Absolutely, right, which is part of my rationale in suggesting a very limited final brief. Both parties have spent a significant amount of time already briefing the legal issues in this matter. All of that is in the court file. I have access to it, I've reviewed it, familiar with it, and so I don't know that rehashing all of it again is useful for anybody or good use of your time at this point. So certainly to highlight the most critical pieces now that you know how the evidence has come in is fine, but to go much further than that I don't think is particularly helpful. So.
Your Honor, at this point, I think my proposal, unfortunately, would be to ask for 30 days, in part because part of our team is out of the country later this month, and I just, to make sure that we could get all of our thoughts together and complete that. I know 5 pages isn't that much, but
April 4th is a Friday. Otherwise, March 31st would be exactly 4 weeks from today.
I think we could probably,
Your Honor, there is a major conference that I think a number of people on applicant's side are attending.
Probably shortly after this period. It sounds like they're asking for a 30-day period to file the last writings. March 31st is the day Daybell starts.
That the first day of which is April 4th, and I have some professional responsibilities at that conference. I can't move, unfortunately. I don't know if it'd be possible to make this due the 8th instead.
The 8th of April?
Yes.
Yeah, okay. Does that date work for this state?
Is the court seeking simultaneously filed?
Yes, yep, just a one.
Yes, I feel that. Yes, the deadline works wonderfully.
Okay. So April 8th, 2025
Yes.
by 4:30 PM.
Get to the closing arguments.
Okay, if we plan on coming back at 3 o'clock for final arguments, 15 minutes, and a final 5-minute rebuttal.
thank you, Your Honor.
Okay, I'll see you then.
Well, 20-minute break before we get the two 15-minute closing arguments. I don't know. Let me see how far away I am from you guys, because I had a poll up what she would rule. 70% says no new trial. I can't even. Where will they go with the closing arguments? The problem is, I don't feel they haven't built a foundation they can. We are 6 days in, and I have the only memorable moment from this trial was that the ME never looked at a wound trajectory, and the only one who did it was the biomechanical engineer. I think that's that's the only memorable thing I have of 6 days of trial. And how are you going to spin that into he needs a new chance? Because feeling he was getting the raw deal is not an argument. You need to give the judge something she can overturn the ruling on. Yeah, but this isn't in front of a jury. They'll just annoy her if they go longer. Bench trials, you don't need these stupid long closing arguments that lawyer thinks that you need in front of a jury. I think, and I might be alone on this position. I know a lot of other law tubers always think you can always speak longer. But I disagree. I feel a closing argument should never, ever, no matter how complicated it is, should never be more than 45 minutes long. Because if you take longer than that, you'll get into all kinds of attempt to tell something, and you'll lose the most important part. And again, as we all have the same reference, I think one of the mistakes they did in the Karen Reed trial was not just hammer home bullet points. hammer home the science, tell them that she didn't do it, and talk about what is the reasonable doubt. I think a lot of times when lawyers start talking, they forget they are talking to layperson. They always want to talk about the law, and they want to talk about how this and that works, but the jury don't give 2 cents about it because they don't understand the law. We sit here and we watch this day after day, month after month. We know more about the law than most common folks because we find it interesting. But lawyers are nerds. They went to school for a long time to learn about the law. And they have this I can persuade everyone syndrome, where they think if I just talk 5 minutes more, I will have them right where I want them. But I think in reality, because they talk so much, they'll start going over the same stuff, or they'll start up a new line of what the hell, and the jury can't focus on it. And we've seen a lot of closing arguments where we're sitting here thinking, what the hell? Like the Sarah Boone, well, I'm just a small town lawyer come in big city, and you've been also kind down here in the big city to me little country folk guy. And we were, what? Why are you doing this? You're a lawyer with 30 years of experience, and you're giving us the small country lawyer spiel. I think 15 minutes is more than adequate in a bench trial because they don't have that much. Yeah, but it's another safety net. And we have seen cases being overturned. Did you miss a part day last week? I remember you suggested we could watch some Recovery Addict. I think that may have been the forensic pathologist. I missed the day with the Karen Reed stuff, and I missed Friday afternoon. I always defrost larger pieces of meat. Well, that's because it's bad lawyering. You need to keep the time limit. What would it have changed if he had 2 hours to talk or 5 hours? Heck, let's give him a day each. No one would have remembered anything he said. No one. It's a mistake people have that they think the longer I talk, the more people listen. Trust me, bro. I talk a lot because I have to fill a lot of breaks. I can't even remember what I say when I'm done. Everyone knows, every study shows that an average person can't concentrate for more than 45 minutes at a time. You need to stand up, stretch, walk around, and then return. That's why lessons in school are 45 minutes long. And this is old studies. Today, with the new TikTok generations and how we have been used to just scroll through everything, you probably have to be even shorter. I think especially lawyers need to learn you can't just yammer on. In a case where some cases you can't even take notes, so how are you gonna remember whatever they are talking about? I believe lawyers need to be better. That's my clear. And again, I was a politician for many a year. If I was told I had a 5-minute opening, I had 3 minutes planned because you'll always talk too long. And we see that a lot of times with lawyers too. And they start rummaging around the papers because, I actually am 10 pages behind. I believe lawyers should learn from politicians. Remember that if you have 5 minutes, you only plan for 3. And I think it's a big mistake to think that Alan Jackson could have changed anything if he talked for half an hour more or an hour more. He wouldn't have changed anything, because what was the problem, according to the jurors who have spoken? We didn't believe the ARCA guys. He couldn't have convinced them of the ARCA guys if he had spoken for a day longer. He wasn't allowed to testify that the ARCA guys was hired by the feds. They would have run into the exact same problem if he had talked for 2 days more. They didn't believe the experts. They didn't understand the cell phone expert, and they didn't believe Dr. Russell or the ARCA guys. You couldn't have talked your way out of that one. So it has nothing to do with the amount of time he spoke, because that's what we know from who talked after. We didn't believe the experts. That's a great saying. The mind can absorb only what the body can endure. This is a bench trial. She read all the motions. She's going to read all the supplementing motions they're going to file. She read all of it. She already made up her mind. This is more for show. It could be. If you want to see a really bad lawyer, because he seemed way in over his head, and he was just, hey, yeah, I'm jumping on what the state claims, and I'm just saying someone else did it. Our man Tom Gillis. How you doing, Tom? I get your shorts in my shorts feed now and again. Get a little tickety thumbs up. On this channel, that could mean another thing. Why wouldn't you defrost a steak or a roast before you? I don't know. I am. Oh, I should make a pork roast. It just takes so long. It takes like an hour and 10 minutes, and I don't have. No, I don't have. Because Sunday I'll be traveling home from Copenhagen, and then I might have that panel show at the. I want to make pork roast now. I don't. This is a good Christian channel. Stu, you ladies really need to get your head out the gutter. It's I don't know why you ladies are like that. It's a crockpot bandit one that can also do the same as the Instapot. I don't know any. I have an air fryer. And a microwave oven. That's the most high tech I go. I really like the air fryer. I'm not one of those who I make everything in the air fryer, but it's really convenient when you're streaming that you can just chuck it in without opening up the entire oven. Well, if she says it's okay, you better do it. What's a crockpot? Yeah, I don't know what this is. A slow cooker, multi-cooker. A slow cooker is perfect for people who want to eat nourishing dinners but may not have the time or energy to do all the preparation at the end of a busy day. This convenient cooking method also means that your meal will taste great and be packed full of flavors. The gentle cooking action reduces damages to vitamins and retains more of your food's nutritions and flavors. When you're cooking for two or making a meal, I don't cook for two. I don't have a life. I only have YouTube. Or making a meal for the whole family. They're really rubbing it in. The slow cooker's generous 3.5-liter capacity can easily cook up to 4 portions at a time. It even comes with a selection of recipe ideas to give you a little inspiration. What is is it like a pressure cooker or what doesn't I understand this? I just don't understand what it is. What's the difference between a slow cooker and a crockpot? Crockpot is just a brand name. I don't know if I understand what it is. Jamie, what's a slow cooker?
I mean, that's a crock pot. You just put something, like you put a roast in there and you just put it on low and let it cook for, what, like 4 hours, 5 hours, and then it's just like fall apart. Like,
But is it sealed like a pressure cooker?
I mean, it seals, but it's not a pressure. The Instapot is more of a pressure cooker. The Instapot's like a crock pot express.
It sounds like that sous vide that everyone started doing a few years back. That's
Yeah,
it's
usually
too fancy for me. I'll just use a pan or a
you
oven.
would love it because you can just throw all your ingredients in the like slow cooker and just set it in the morning, and then by the afternoon you have a hot meal ready for you.
Oh, Panilla found me the one I need to buy.
What? Exactly.
That's the one I need.
You need to get one just for that. You can make dips in it, and I mean,
I don't like
us
dips.
Americans love our dips.
Yeah, I don't like dips.
You make ribs in a crock pot.
I don't like ribs.
Roasts. Oh my God.
But I don't like anything that has barbecue sauce on it.
That's the key word. You don't like anything.
Really, miss? I don't want to eat herring.
Okay. Come on. Herring.
It tastes delicious, Jamie. And it's really good for you. That's a lot of important fish oils in it.
It's okay. I'll just stay a chubster. I'm okay with that if I don't have to eat herring.
I don't know why you have to be so hateful about it's my culture, Jamie. Are you saying you don't like minority culture? Because we are only 5 million people in Denmark. So we are a very small minority group. And you're just hating on me now? I'm
You can
pretty
keep
sure
your culture. It's perfectly fine. I just will stand on the sidelines and watch you eat all the herring you want.
This is like me saying to Valhalla, no, I won't drink that cold 45 because what's that? What's malt liquor?
Well, you don't have to.
Well, I felt I have to celebrate that culture. And I drank it out of brown paper bag as well.
Mm.
Jamie. I am... in Denmark, we have it's I don't know what part of the pig, but it's called like good bones, I think we call it, but it's more not smothered in something. It's just boiled up bones that you chew the meat off. That's something that a lot of old people really loved, and I'm not a big fan of it. I have a big 8-quart one, but I think you can get them small, like 2 and 4 quarts.
Oh yeah, I have a little baby one that you can do like dips in and stuff. Just like a little guy.
But isn't this is just, you can just put a pot on your stove and it's the same thing.
Not
If there's
really,
nothing
'cause you
special.
don't have to watch it.
I can be in this room and have something on my stove as well, Jamie. The
Well,
fire hazard is just as big.
I don't like all that. It feels like it's just nice. It's just nice, Baker, okay? I don't know how to explain it.
Thank you, Tracy. Finally, someone who is normal.
You can just throw it all in there and leave it be for the day.
I'm not a fan of seasoning. I made because I slow cooked yesterday. I made a whole ton of well, we call it meat sauce in Denmark, but it's not. But you roast some meat and you put in vegetables and beans and tomatoes and stuff like that, and then you can chuck it on rice or on spaghetti or whatever you need it to. And I always season a lot. I'm particularly fond of putting curry into my food when it has to, because it makes it a little more interesting when you eat it on the 5th day in a row. So I like that. A lot of garlic, a lot of chili. I just don't like barbecue sauce because it has artificial smoke flavor, and I hate that.
Well, and everybody's making a good point that I should have made, but the crock pot's different than a pot on the stove because you can leave the crock pot going and you can you don't have to, you can leave.
I can do that with my stove as well. It's the same fire hazard. It's a heating element. It's a heating element.
Because it's insulated, so it's not the same as having just an open pot on the stove. Because it's there's a contraption around it, and then the pot actually goes inside, and it stays heated inside that. So it keeps it all inside.
I could actually have it and then put it in my shed outside. So if it burns down, it's just my shed that burns down.
Oh my God.
Because they never had real barbecue sauce. I ate barbecue pulled pork at a congressman's house in the South. I don't think you should tell me about me having real barbecue sauce. I'm just saying. I'm probably had more real barbecue sauce than you, because I got it. I got it from the authentic Southerns. I don't know where he bought it, but it was okay. I'm not a big fan of pulled pork, but it's probably because everyone started eating it like 10 years ago in Denmark. And, I'm going to put a roast on and then I'm going to shred it in 45 days because then it's so good and tender. No, just roast it.
Oh my God. You. I don't know what to say anymore.
Yeah, but I don't have a gas stove because I don't live in the Middle Ages. Oh, if I could have it, yeah, I could just sit here and say, bop, bop, bop. Well, I like pork. Just don't like pulled pork.
You can put chicken in there, all kinds of stuff.
Consider I've made it homemade and been to Nashville. That's like saying, well, I have a black friend. It doesn't make you Southern just because you've been to Nashville. And trust me, Valhalla tried that trick a lot of times, said, well, just trust me. I have a black friend. And I said, well, Colt 45 is still not a great beer.
I don't really like the fake smoke taste either, but that's just me. But if it's done right.
You can make yummy desserts as well. I don't like hot desserts. Well, a dessert should be cold. It's an after dish. I like puddings or ice cream or stuff like that. Maybe some like what do you call it? Preserved fruit, where like pears and peaches in syrup with some nice whipped cream on. Oh, that's good, especially just around November when it's getting dark out and you're just enjoying that. I like that.
Well, you can do like dump cakes in your crock pot and then you can just let them cool
You
down.
can do what?
Like a dump cake. Your favorite box cake mix, and you dump a bunch of stuff together. And then it makes a cake, and then you just have to let it cool.
You're gonna make me sound like Auntie Bev. Hot apple crisp with vanilla ice cream. I like a good apple pie.
Yeah, you can make some apple pie in the crock pot.
Yeah, put that in.
Really selling it here. Come on.
No, I would rather have a pulled pork, pickled herring than pulled pork.
Yeah. You are crazy.
Yeah, you learn about culinary things instead of, I'm just going to take a box of something and toss it in and then I have a cake. No, Jamie. Then you have a bunch of chemicals.
It's delicious chemicals.
I'm not a big fan of chicken. Whipped cream on herring. No, you don't do that, but that's a 70s recipe. Oh, that's the most horrendous thing in the world. I don't know if it's real, but
I know Lefty. He hates the box cake stuff.
you just make a real cake. It doesn't take longer to just make a real cake.
It's just easier. It's already flavored and everything. Got everything you need in the box. You just add like an egg and some oil and you're good to go.
Yeah, and you can just add some flour and some cocoa and some sugar and some vanilla. It doesn't take longer, Jamie. And you don't have all the artificial things. Oh, what's it called?
You can, I know, but it's just easier. Because how much does a box of cake mix cost? Like $1?
Yeah, it's way cheaper to buy the ingredients. How many cakes can you make out of a box of
Like
cocoa,
a regular regular pan of cake? I don't know.
Yep. I wish I could find that. I can't remember. It's called Russian something or herring with covered herring or something. It's the most horrible thing I've ever seen. It's a Russian recipe where they use entire herring and then chuck like mayonnaise. Oh, you would love it. They chuck mayonnaise on top of it and beets and stuff like that. It's so weird. Nope. Put on the audio.
Ms. Thompson, you ready to proceed?
Woohoo, Ms. Thompson.
Oh my gosh.
Your Honor, Todd Mullis has spoken the truth in this case from day one. He said this was an accident. He asked his attorneys to investigate it as an accident. He gave multiple consistent interviews. He testified at trial. He testified at child guardianship proceedings that are part of the record below from his motion for a new trial. He filed this PCR, a verified PCR. He provided affidavits. His belief has been consistent and has never wavered that this is an accident, that he was in no way involved, and that he wanted his counsel to pursue that issue for him. That's different from other witnesses who testified at this proceeding and whose stories have changed over time. There's nothing that Todd Mullis could have said to this court that he hasn't said before. And that's why this post-conviction hearing has been about all of the evidence that should have been presented at trial to support what he's been saying all along. The court has pointed out that this is an evidentiary hearing, that all of the evidence this court is going to consider is not evidence this court heard in court during the last 6 days. Because as we just went through, the court will have depositions, the court will have documentary evidence, the court will have other evidence from the underlying record that wasn't part of what the court heard, specifically in testimony and at this hearing. But all of that together demonstrates that Todd Mullis's trial was fundamentally unfair, that the system broke down, that he did not receive the fair trial that he deserves. And that is the outcome that Mr. Mullis is asking this court to assist with now. This court really can't think about what Mr. Mullis's claims mean without thinking about what it is that actually happened at his trial. What happened at his trial was that everyone, his own counsel, the state, told this jury that Ms. Mullis's death was a murder. His own counsel agreed in opening statements that Ms. Mullis was murdered, and that belief was allowed to be presented to the jury with zero adversarial testing. I mean, this was the quote-unquote strategy that his counsel pursued at trial. Their strategy was, we're going to concede it's a murder. That's a strategy they reached on the fly, which we'll talk about in a second. And as Mr. Firehelm told this court when he testified here, Todd's going to explain it. Todd will explain all of the evidence, and that is the way that they provided counsel to him through this trial. Their strategy was Todd is going to explain the text messages. Todd is going to explain whether he knew about Ms. Mullis's affair with Mr. Frazier. Todd is going to explain the Google searches. Todd is going to explain the state of his marriage. Todd is going to explain what was happening in this argument between his wife and his mother. Todd's going to explain these hearsay statements from these witnesses. Todd is going to explain without any notice or understanding that he even needed to prepare to think about or testify about this 911 call and what he said and who was there and what he was thinking when he was frantically providing aid to his wife as she was dying. Todd's going to explain the state's circumstantial evidence that is meant to show that he was guilty. And that in effect became a trial where counsel is telling the jury, even though I told you in opening statements that Todd was wrong, believe him that he's not guilty. That is not a reasonable strategy. It's simply not a reasonable strategy, and it and all of the errors that combined cumulatively to deny him a fair trial, denied him a fair trial. There are two Sixth Amendment claims that Mr. Mullis has in this case, and they're different. We talked about these at summary judgment, but I want to talk briefly about them now. One is the Sixth Amendment claim that Todd has the right to be the master of his own defense, and we spent a lot of time on that claim at this hearing.
It's called herring in a fur coat. Google it.
Herring in a fur coat.
Yeah, it's... Well, you have to Google it. It's with potatoes and stuff like that.
Oh.
Hearing from various witnesses, and I know the court has the law on this that we provided at summary judgment. The law is that Mr. Mullis has to explicitly consent in opening statements, or has to explicitly consent to his counsel conceding his guilt in the trial. He has to explicitly consent if that's the strategy. And from all of the testimony the court heard, from Mr. Firehelm, from Mr. Sabers' deposition that the court will read, from all of Todd's letters and his testimony at the child guardianship proceedings that are in the record, that simply never happened. Todd, this resulted in a situation where his trial counsel conceded his guilt because he told the jury that Amy Mullis was murdered in a situation where the lawyers were going to provide no evidence to establish that that was not Todd Mullis. The evidence is undisputed that Todd Mullis didn't know his counsel was going to do that. The court has Mr. Sabers' deposition, who testified at a deposition, and the court can review this, that he was surprised at opening statements. He was surprised to hear that that was the position the defense was going to take, that Mr. Mullis was surprised. The court has all of his letters. The court has heard from Lynn White. The court will be able to review Todd's testimony in these child custody proceedings. Todd said he never gave counsel permission to do that. All of his letters support that that's not what he understood the strategy was going to be. Mr. Sabers didn't know that was going to be the strategy. That happened without his permission. And we explained already why that's important, because if that happened without his permission, then this isn't a matter of prejudice. It's not a matter of establishing what the outcome would have been if counsel followed a different strategy. That is just a Sixth Amendment violation, period, that really ends the analysis. And on that basis alone, Mr. Mullis receives a new trial. But that's not the only aspect of Sixth Amendment. That's not the only aspect of a Sixth Amendment violation that is present here. We have a more typical ineffective assistance of counsel claim too. And this is very important because in this case, there is no reason, and the court heard no reason from Mr. Firehelm, there is no reason in Mr. Sabers' deposition to explain why it would have been reasonable for trial counsel not to investigate and present evidence that corroborated everything that Mr. Mullis testified to at trial. To investigate and present evidence about medicine, about the electronic evidence, about these Google searches that we've been talking about text messages, about the cameras. There is no reasonable strategy that would have allowed counsel to not pursue any of this evidence, and instead to pursue what they did at trial, which is to concede this was a murder and to let Todd explain himself unaided to the jury. What's important about this, and what we want to make sure the court understands, is that even though in this evidentiary hearing, the applicant has spent a lot of time presenting evidence to the court and proving to the court that Mr. Mullis didn't agree with counsel's strategy, even if Todd Mullis never wrote a single letter to his lawyer, even if he was maybe a person with a little less understanding about the way that biomechanics work, his instincts about what might be true. Even if we had none of these letters, even if we didn't have the vast record we have here that Mr. Mullis was asking about these issues, that he wanted this to be investigated, that he was seeking investigation, that he consistently and unwaveringly believed that his wife's death was an accident, even if none of that was true, and Todd Mullis had just said to his lawyers, give me the best defense you can, I don't know what happened, but do your best. If that's all he ever said, counsel would have still been ineffective. It is not Todd Mullis's job to have told counsel what the right strategy was here. As it so happens, he did. But even if he didn't, it doesn't matter, because there's no reason not to investigate these issues. This is not dependent on what Todd Mullis agreed to or not. It is ineffective for counsel to have chosen the path that they chose, and that is because they chose it without a reasonable investigation. We cited law to the court in our summary judgment briefings, and we will cite more law. The United States versus Hinton, the United States Supreme Court has said that it is ineffective for counsel not to understand science and not to get experts in a case where expertise is required. And Your Honor, this is such a case. This was clearly a medical case. Mr. Firehelm told you, I relied on my own understanding about this. You know, I was first chair, I made these decisions. I relied on my own understanding to decide that there wasn't anything I needed to pursue there. Under Hinton, under the other law that we've cited to the court and that we will cite, that's ineffective. The state may point out when it speaks to the court that in his deposition, Mr. Sabers did describe, you know, as the second chair, as the person who was not making decisions in this case, some of the things that he tried to do, because he did try to do more than Mr. Firehelm did. For instance, he himself went to the shed. He looked at these augers, and he talked about that in his deposition. He also read the case materials, like Mr. Firehelm did. But there's no evidence that Mr. Sabers discussed these issues with Mr. Firehelm other than telling him that he'd visited the shed and looked at these augers. And there's no evidence that Mr. Firehelm did anything that Mr. Sabers asked him to do. The state's own exhibits show this, that there is a email from Mr. Sabers to Mr. Firehelm where they discuss we probably should get an expert. I mean, they knew that Todd was asking them to do that. They agreed they probably should get an expert, and that just didn't happen here. They never provided case materials to an expert, either a pathologist or a biomechanical expert, who could explain to them that there was a defense here, a reasonable defense that they should have followed. They just didn't do that. And Mr. Sabers, doing his best to look at a couple of things, to give advice to Mr. Firehelm that he never followed, that's not a strategy, that's not a decision, that's failing to do what you know you should do. And there's no reason that the state is going to be able to articulate for not following the...
Baking is so much easier than cooking. I don't understand you people. What do you mean, you people?
Only reasonable strategy here. That leaves us with the question of what this trial would have been, the prejudice issue of Strickland, if Todd Mullis hadn't been standing alone at his trial without any of the assistance that his counsel was supposed to provide him. If his lawyer wasn't just saying, you know, trust Todd, what would the jury have heard? And at the end of this hearing, especially hearing the evidence the court's heard here in court, considering the other materials as well, the court knows the answer to that. The court knows that if this had been a fair trial with effective assistance, this jury would have heard that this was not a murder. And it would have heard that from sources that are far more credible than the state's witness who testified at trial without any cross-examination, save one question, that this was a murder. This was a medical case. And the court heard extensively, and I know we spent a lot of the court's time making sure that the court could hear the opinions of Dr. Cruz, the opinions of Dr. Hammers, the opinions of Dr. Nye, to decide what the true state of the medicine is. And based on that testimony, there's really no question what the state of the medicine is. This is not a murder. This is not a homicide. This is an accident. Dr. Hammers was able to talk about that from a pathology perspective and explain why, despite there being unopposed testimony offered at trial that Ms. Mullis had defensive wounds, that there was nothing about the state of her body or this autopsy that indicated that she was the victim of a homicide, but that this was an accident from a pathology perspective. The court knows that Dr. Cruz said that she couldn't really figure out how this happened. She just couldn't see any reason that it was an accident, and that is essentially why she determined this was a murder. After 2 to 3 hours of doing this autopsy with other autopsies, she came to that decision, she stuck with it, and she made that decision without the benefit of any biomechanical testimony, any biomechanical advice or assistance. The court has that assistance now from Dr. Nye. Dr. Nye started looking at this case to review the opinions of others, and we're not asking the court to even consider that piece of what she did, because she then went on to do her own investigation. She did her own visit to this scene. She did her own consideration of the wound pattern. She did her own force calculations. The court has her math on her notes where she went through and actually figured this out, figured out the force that would have been required to fall from a standing height, from a kneeling height, figured out the force that would have been required and the direction of the force that would have been required for this to have happened in different ways. And from that biomechanical evaluation, she told the court that the only hypothesis that she can't disprove is that this was an accident. And there is no other biomechanical evidence before this court. If the state wanted to call a biomechanical engineer, or really any witness, to say that Dr. Nye was wrong, they could have done that. That's not what they did. Dr. Nye testified without any opposition. Dr. Cruz said, I really can't speak to those issues. And that's testimony the court has to consider in deciding what the state of the evidence is here. I'll go through the other evidence the court heard briefly, because the medical evidence is the most important. The court heard that despite at trial the unrebutted testimony, save from Mr. Mullis, was that all these searches were from the iPad and that they were very nefarious. And when the court actually gets a chance to see that those searches didn't come from the iPad, that many of them came from other devices, and the actual content of the search, that these searches are related to hunting tests, they're related to television programs. The actual content of the searches and the evidence that they didn't come from the iPad tells you that Todd's testimony was right. The court will have a chance to look at all of these texts and emails which are in evidence, and the court heard from Mr. Safarik and others about what all of this electronic evidence means. And it proves what Todd said, which is that even though his wife was having an affair, this had not bled over into the marriage, that he didn't know about it, that they were living relatively happily, despite the fact that there were sometimes, disputes with a mother-in-law. None of this was creating this situation that resulted in some planning to end someone's wife's life. I mean, there are text messages with Todd right up until the end of Ms. Mullis's life where she's saying, I love you. The court has Tristan's testimony, and it should evaluate it, that Tristan has explained why he testified as he did, and that his dad was really only out of his sight for a short time. The court knows about the 911 call. It heard a lot about that, about the discovery violation that occurred there, and that this was a trial by ambush with respect to this 911 call, and that 911 call is not what the state described, and that Todd was with other people, sheriffs, when that happened. There's a lot of other claims that counsel presented, and the court knows what the evidence about that is. Based on the evidence the court has, it knows that Todd's established his Sixth Amendment claims, it knows he's established an actual innocence claim, and that this is the rare case where, considering these claims separately or cumulatively, that a new trial is really the only fair outcome. I'm going to come back and talk in rebuttal in a minute, but based on what the court's heard, there's no doubt that Mr. Mullis's trial was unfair, and there's just one result from that, Your Honor, which is a new trial.
Thank you, Ms. Thompson. Closing argument on behalf of the state.
Thank you, Your Honor. May it please the court. Good afternoon. I will be brief. The state submits that Mr. Mullis has not met his burden of proof on any of his claims. We ask the court to deny his application in its entirety. In addition to the record and issues that have already been developed at trial and before it in this proceeding, we will address our legal reasoning for why each of his claims fail in our written brief. Thank you.
Thank you, counsel.
I like that. Yeah, we're going to write you a letter anyway, so let's just shut up and get out of here.
Your final
No, I
rebuttal.
want to hear what they have
One
to
more
say.
thing.
Jamie, I like it.
Well,
Give me
it
this
doesn't
one.
have to be long-winded, but I kind of wanted to hit some points at least.
Yeah, but at least he's going to put in some legal stuff. It's not like Brennan, who never puts any case law.
Which is that although we believe that we've established Mr. Mullis's actual innocence, which means that there should not be any new trial, if the state concludes that they want to rely on Dr. Cruz and retry him, that's an opportunity that he should have an opportunity to present this evidence to the jury. Because the last thing I'll say about this is the court may conclude in looking at all of the evidence, both what it heard here, what it reads in the record, and it may determine, well, I see some evidence on the other side. You know, I see some evidence still that for me, I don't know what to make of that. I see that the state made some arguments at the original trial, and for me, I don't know where I end up on actual innocence. The court can have questions as a result of this hearing about what happened, but as the court knows, those questions are the province of the jury. It is for the jury to decide if it believes Mr. Mullis. It's for the jury to decide if it believes this other evidence. But this is all evidence that the jury should hear. Because Mr. Mullis has established there is at least a reasonable likelihood that the outcome of this trial would have been different, with the overwhelming evidence that the court has seen, that it has read and will read, that it's heard. This is evidence of an innocent man. This is evidence of a man that deserves a new trial, and a trial where he can have his day in court. And for that reason, Your Honor, we're asking the court to grant Mr. Mullis a new trial, and we'll provide additional legal briefing in the post-trial briefing that we make in a month, Your Honor. Thank you.
Thank you, counsel. I will await both parties' final briefing by the April date that we previously discussed. At that point, I will consider the matter finally submitted. Counsel, if you maybe just want to touch base with me briefly in chambers before you leave so that we can make sure that everybody is on the same page as far as the exhibits that were admitted. And then I'll give you a day or two just to review any final security level issues before I file the exhibit management order. Other than that, anything that we need to address before we go off the record? Anything on behalf of the applicant?
No, Your Honor.
Okay. Anything on behalf of the state?
No, Your Honor.
All right. Thank you all for appearing and for your cooperation to keep things moving throughout the trial these past days. Thank you.
Yeah, he doesn't have any plans. He can live with that. I'm not sure still that there has been enough new evidence put in that could sway her to give him a new trial. I just don't think so. I don't know. Jamie, where are you at?
You know where I'm at.
Yeah, you are at that. It's he should have had a new trial, but based on what we have seen.
Well, I still think that seeing some of the alternative evidence, such as the biomechanical engineer, raising just, I don't know, I don't think the Google guy was the greatest, but just raising some of those questions of like, it didn't, because obviously now that I've saw the testimony of the guy, the cop, I know he said, oh, it came from this iPad on his account. It's only him and only him alone. And to raise some of those questions for me, but see, I don't know what the judge is going to decide. But for me, those are questions to be like, okay, this is questionable.
But my biggest problem is I didn't see where they wanted to go with that Google expert, because all he did was they were talking about could he Google on a tractor. So I don't think that
Well,
that's enough to sway anyone's opinion and say, well, he clearly needs a new trial.
I guess the pieces that I latched onto were showing the stuff he talked about when he said it was, it wasn't just one device, it was multiple devices. And that's not what they testified to in the first trial. So that for me is kind of like, okay, that's interesting. And then the biomechanical engineer is very interesting. And I like that FBI guy. It was just kind of, I mean, I don't know how much that's gonna weigh on her, but to like understand how much tunnel vision there was on this case and how they were, I don't know,
Yeah.
especially the planning part, because obviously he got convicted of planning, and that's why he has first degree and no parole, because he's a sadistic man who planned this whole thing. So
And Nina, I know I missed a full day of evidence, but I also know that I watched the last 5 days of it, and there was nothing. So, unlike Jamie, who because she watched the first trial think he got a raw deal, I will be the red pill guy and say he had one trial, he had one appeal denied. This is already trying to hit the moon with a baseball while batting into the ground. You have to be insanely lucky for the judge to change her opinion, because they did cross-examination on every witness. They could have pointed out all the mistakes in the first trial. I just have to say that other than the biomechanical engineer and maybe the forensic pathologist, as you said, was on the day I didn't cover. None of the other witnesses did anything for me. Nothing. Because it was just, could have had happened. That's expert v. expert. And that's opinion. It's not, I don't think it's enough. Do I think he had a bad case the first time? Yes. Do I think he had a bad lawyer? Yes, because I listened to the lawyer talk. But I'm watching this trial and this trial only, and I haven't seen enough reasonable doubt being put in here. I have to be honest with you. I could be blowing smoke up everyone's ass and say, yes, oh, he's clearly innocent, and that's not what this trial was about. It's about establishing enough doubt about the first trial that he should have another one. And yes, the ME seemed like she was sloppy, but she did her job. She stood by her findings. The only thing you really had and again, I didn't see the pathologist, but she didn't measure the wound directions. But she believed, based on all her findings, that this was a murder. And then there's other experts who have the opinion it was an accident. That's a battle of the experts. We see that in every trial.
mm-hmm.
And
unfortunately,
if
they
it's,
didn't do that for him, and that bothers me.
Yeah, but it has nothing to do with what we're watching here today.
I know, but that's part of what they're talking about is, his counsel.
Yeah, but they never
and what they
proved it.
didn't do.
They didn't in any way make it clear to me that was what they were talking about. I know it because we have discussed it in chat. I find that if he had an ineffective counsel the first time, he also have an ineffective counsel this time. I don't think they have proven what they were going for.
I mean, I get where you stand. I just see it a little differently.
Yeah, the problem was what I would, if we were going by the Google searches, I would have gone in there and said everything is taken out of context. But I spent more time listening to when do you seed beans in Iowa? You do that in May. Why do I know more about bean planting season than I know about what was in these Google searches and why they believe they prove it must have been someone else who Googled it. That's my big problem in this. This is a bench trial, and I don't think she's new. I think she looked experienced.
I just cannot I can't sit and honestly say that I mean, obviously I just watched the first trial, and it bothers me the type of information that they put out there that was completely incorrect. And yeah, I get it, like he had lawyers and everything, but they did not. It bothers me that they didn't even try to
Yeah,
like.
but you're doing the wrong thing. You're taking your emotions and put it into the legal system. It doesn't belong there.
No, I'm just saying they didn't bring any experts in to counteract anything, and they should have. I think
Yeah.
should do that for anybody, especially when they're offering it up. And if it's true, he's sitting there saying, "I don't want this defense. This is not what happened. It's an accident." I mean,
Yeah,
that's a problem too.
then they should have treated it differently. I agree. He got a really shitty deal. His lawyers were lazy. He didn't want to do his job.
Well, I hope that's
We both
enough.
agree on that. But I'm just saying I don't think there was enough here. But they don't need to show you. They need to prove it to the judge who have seen everything, including the record. Yes, but then why have this trial? Then we can just file a written application with affidavits and say, yeah, the witnesses they have provided to court must be to sway the judge that these witnesses should change their mind. And maybe it's the questioning, maybe it's the skill of I wouldn't put it on the experts. I think all the experts were good. Let's put that over here. I think they had good experts in this case, really good experts. I think they had really bad counselors. That and I really didn't. I think that it would have landed better if they had asked better questions. Maybe
Well,
it's
yeah, I think they need to.
that's why I'm saying if he had an effective counsel the first time, he had it the second time as well. Because I really feel that you could have gotten further with this if you had honed in on what is it we need to get out here and put out to make the judge aware 100%. And I think those Google searches, hearing what's in them, I'm quite annoyed that they didn't get some metadata on them. When was the search for the bride dress? When was the at what time of day was the search for how to unalive women with a corn rake and make it seem like it's an accident? I want to know when that search was, because maybe it was for a school project.
Yeah.
And
Well, that's the thing is he testified to all of that and they just allowed him to go and say these times that were not correct, and
yeah, but that's
with
what
no
I'm saying. They
context
should
to
have.
him. And that's what bothers me so much, that they didn't even try to correct it.
And they didn't try to correct it this time either. Even the people who called and the witness to testify about the Google searches didn't clearly say, well, this went to how did you treat adulterers in the Middle Ages? This was 2 months old and it was searched at 2 in the afternoon. So that was for a school project. We're talking so much about metadata and stuff like that, so I just can't get why they didn't give us the timeline for those searches. They only mentioned they had 11 pages of Google searches.
I agree that they didn't make it very clear. There was some stuff that was cleared up for me. I mean, him being able to testify that this was not just searches from that iPad, as the cop claimed before. That was nice to know. And then talking about how he didn't know what UTC time was, and he kept calling it military time, and that wasn't correct either. I mean, it
No,
shed the
military
light on it.
time is the correct way of watching time. That there's 24 hours in a day, not 2 times 12 hours like Americans believe.
Well, that's what he called it, because he said, this is
Yes, yes,
military
yes.
time,
But
and it was not military time at all.
no. I'm just saying that that's because you Americans think that the day isn't 24 hours long. But
Mhm.
I think there's a low likelihood that he's getting a new trial. I would say if he had gotten the appeal, there was a higher chance that he could get off. But I think the judge will sit and say, well, he had one trial, he had his appeal denied.
Mhm.
So I think if this had come in at the appeal, which it must have, that's the time to get it in there. I don't know. What do I know? I'm just an idiot who rambles. I'm not a professional opinionist like. Did you see that, Jamie? That we have competition now.
What?
Casey Anthony is becoming a streamer.
Uh-uh.
Yes,
Oh my
she
God.
she's been she's been she's gonna give legal advice, which
Tell her, I'll give her some advice. Go walk into a volcano, Casey Anthony. Please do. You're the worst person on the face of this earth.
she's gonna have an email address where you can reach out to her, Jamie, so you can ask her legal questions.
Yep. Oh, I'll get right on it.
Farrell will probably get on it before you.
Yeah.
Ask her if she knows a good friend of this channel, Lord Chippy.
Oh, fine then, Danny. We'll go get her let's go rent a wood chipper and we'll just invite her over for drinks and push her right in.
I was a bit shocked when I saw it, so I had to play the video. And she's doing the thing that I will start doing now. She's recording in her car because that's what true professionals do. They don't sit in a studio, Jamie.
Ugh.
They sit in their car with their phone on the steering wheel and then just, yeah, I've been in connection with the system since 2011, and I'm going to be an advocate for my daughter.
You unalived your daughter, you dumb A. Jesus.
She was not found guilty in that, Jamie. You have to remember that.
I don't believe it for 1 second. Now, why can't most people that are actually not guilty get that jury?
Well, I don't know.
I don't remember if they actually came out and talked about it, but that's a jury I would love to hear from. I think it was a lot to do. To be honest with you, I think a lot of the reason was because they made it a DP case, and a lot of people have a problem with the DP.
But she sounded like every other I'm gonna get rich of YouTube streamer. Oh, well, she's gonna do it on Substack, so you have to pay for the joy of listening to her. But she did I'm gonna be an advocate for LGBTQ, the LGBTQ community, and because of the way our society is in America right now, and politics and blah. She was hitting all the buzzwords to drum up some traffic. It's wonderful, Jamie. When I hope that the only 5 people who buy her Substack is Farrell, and her parents, and all of them will just write her, go jump in a lake. I'm not going to talk about my parents, but I will at some point, and the things they have said. Yeah, you
said
should.
enough. You've said enough, lady. Tie a rock to her leg and jump in a lake. That's what we need to tell her. It'll be fun.
Yeah, she was overcharged. Yeah, we agree on that one, but
Yeah, I think it was an overcharge, and that's kind of why she got the good old deal she got. Because, ugh. She is the poster child for just a straight up liar.
Who was it who got famous? Was this? We watched part of it on Farrell's channel. Was there some rumor about her and the attorney or something?
Yeah,
Am I
that
is
Jose.
am I mixing up two cases?
No, there was rumors that like she is giving her lawyers BJs for them to like represent her or something like that. There was just all kinds of stuff like that.
Oh, Jose Baez, and he's become a very very famous lawyer off of that case. Yeah,
He's really good, I will say. He's very good.
yeah. Again, why would you? She's not that pretty. Why would you take a BJ and then she can talk about it and you'll lose your bar? It's probably just a rumor. Well, she worked for him after the trial.
There was
And now
one
she's going to
guy-
give legal advice in her car. Yeah, he's probably not employing her anymore.
Yeah, the older guy that like sat next to her, not him, but the older one. And that I remember when she did that documentary, she was like living with that guy and like working for him and stuff, which is just weird to me.
Oh,
She was like, I can't go anywhere. People are so mean. I wonder why.
yeah. You'll get the sickos who are serial killer groupies and idiots like that. Yeah, like the Danish submarine guy who's getting married for the third or fourth time since he got life in prison for unaliving a woman.
Ugh,
Because people are stupid.
really are.
He's defending Shayna Gardner starting up soon. Is that Microsoft?
Yeah.
Yeah. I'm just annoyed. I've never seen one of the hearings with good audio because it seems like an interesting case, but there's never any good audio. He's no Joan bias. I would hire Valhalla and get freed by a 3-hour goat prison break lol. Yeah. But tomorrow, Jamie, we will have Valhalla on the channel.
Oh my God. Really?
Yes.
He's
I
my
know.
favorite.
I know you don't like me and you like him a lot, so I got him to come on. We're going to start a little before 9, and then we're going to watch the Karen Reed motions hearing part. I don't know. The outstanding motions I gather is the ground hardness expert, Bitterrow being allowed on the defense team, motion to dismiss, had one more yesterday. Motion to throw. Well, we have all the motion to or the sanctions or whatever it's going to be from the last hearing. New motions have been filed today. There's another request for metadata because videos just keep turning up.
I mean, yeah.
And there's because in the last evidence that they turned over, even though they have twice said they turned over everything, there are 8 letters to Special Prosecutor Brennan, and people are already starting to wonder: is it Plevin, Doink, Kim, Krusty? Who's sending letters to Hank Brennan? That's no, that'll be 3 in the afternoon, real world time.
Hey, I don't have a tone.
She has an attitude. That's something else, Valhalla.
Never. I'm the sweetest thing ever. Never have an attitude. I love all you guys.
Patty B, always remember on my channel, I might exaggerate a slight bit for comedic or dramatic effect.
Yeah, he didn't actually. There was no Google searches actually saying how to use a corn rake.
Yeah.
to off your wife.
How to acquire a corn rake, make it look like it's 100 years old, and accidentally push the old ball and chain onto it
Yeah.
and get some kittens to destroy the surveillance camera.
Patty, if you really want to, they have the playlist on
Yeah, Lawn and Crim have it, or
Lawn
you
and
can
Crim.
watch it at Trial TV Live if you want to support good friends of the channel. You can watch it over there. They ran it around Christmas. They're not annoying like me and stop all the time.
and it was very short.
Yeah,
Pretty much you get the brother and sister-in-law of the or the brother of the victim and the sister-in-law, and then the 2 detectives, and then the doctor. And it was really short. And
was
if you
it
want
a
to go
2-day trial?
Yeah, obviously it's split up, but I think it was only 3 days. I think. Pretty sure. I'm not sure. But
we also have a motion to amend the scheduling because of all the new discovery from the state. That's right. Good. That's the one I missed. Sorry.
No, you're fine. I was just saying that if you want to go back and just watch the the cop talk about the Google searches, it's a very interesting to watch and to listen to him, and how he's just nah, this is how it is. And then to some of the searches, I'm just really? But anyways.
Yeah, it's a weird case. That's the thing.
Yeah, it was, and then he testified, and I didn't think he was that unlikable at all, but I could tell where they were trying to get him to cop to stuff, and it was just so awkward.
But we have this, you're always guilty. You must be guilty.
Mm-hmm.
We've seen too many jury cases where we clearly knows that people are innocent and they'll still be found guilty.
Yeah.
So, yeah. Holly Mack thinks he has a chance.
I have hope that she'll see something and be yeah, he should at least get a chance, but we'll see. I don't know how she's feeling.
Before we go, please remember to do all the YouTube. I don't want to say that. Thank you to all the new subscribers we got yesterday. I'm going to chuck you somewhere, but now I have to do the math. At 6 Eastern, yeah, that's midnight. At 6 Eastern, Mo will be covering the case she started, Colorado v. Stacy Rodriguez, the unaliving fire something case. I think she'll start at 6 p.m. Eastern. If you want to go support her, maybe one of the mods, I think the mods have quit, Jamie. They're so mad at me. But please go and support Mo. Interesting case out of Colorado. And she does it with her normal snark and Mo-ness, if we can say it that way. Because she just have that way with words. And I can recommend 100% going into puberty so your voice won't break. But until then, I'm going to chuck you somewhere else. But please consider supporting Mo at 6 p.m. Eastern, where she will cover the Colorado unaliving house fire case. Jamie, any famous words you want to say?
Oh, everybody have a great day. That's really all I care about.
That's famously the same word Abraham Lincoln said just before he went into the Fourth Theater.
Oh, no way.
Yeah. And then Booth said, what are you talking about, Willis?
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
Go
All right, I'm in love.
back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.